Are human rights listed in international treaties and national laws can mean little unless they are protected. Protection mechanisms, which are something that can protect human rights, exist around the world at different levels, ranging from an international level at the United Nations to the regional level, especially three existing regional human rights systems in Africa, Europe, and the Americas, and at the national level, which are bodies that exist inside a state. Each mechanism is expected to play a complementary role in protecting and promoting human rights of all people. The conversation between Joel Mark Barredo, a former MA student in human rights at Mahidol University, and Dr. Sriprapha Petcharamesree, a faculty member of the Institute of Human Rights and Peace Studies at Mahidol University, will give you an overall picture of human rights protection system in Southeast Asia. It will focus on national and regional human rights regimes, especially in ASEAN and Southeast Asia. The module will increase your understanding about different human rights protection mechanisms that exist today and how they respond to the challenge of protecting human rights.
Professor, can you give us an overview of the existing human rights mechanisms today?
There are three different levels of human rights protection mechanism. The first one is the international human rights regime. You have a whole lesson on international human rights system, which includes, for example, the UN Human Rights Council, the UN special procedures, which are part of charter bodies and treaty bodies. The second level is at regional level. So far, you already have three regional human rights protection mechanisms. And then the last one is the national human rights regime, including national human rights institutions here.
And can you tell us more about what national human rights institutions are?
The national human rights institutions is the body with the function specifically defined to promote and protect human rights of the people. It is administrative in nature, so it's not judicial body, and it's not a law-making institution. These national human rights institutions also have the advisory authority. When I talk about advisory here, I refer to advisory to the governments in terms of the respect, protect, and promote human rights at national level.
And what are the mandates and functions of national human rights institutions?
National human rights institutions are expected to have broad mandate, which include protection and promotion. It is also expected to cover private and public sectors. By public sectors, I refer to the government bodies because they have high potential both to promote but also to violate human rights of the people. It has jurisdiction over all categories of rights, including political, civil, economic, social, or cultural rights. And the national human rights institutions are expected to address both systematic human rights violations and individual complaints.
And is there a standard that national human rights institutions have to follow?
Yes, at the international level, there is standard which is called Paris Principles. Briefly, and you can have the detailed Paris Principle. It prescribes for example, independence of national human rights institutions. It also advises in terms of composition and representation of the national human rights institutions, which had to be pluralistic. It also provides for fixed mandates of the national human rights institutions. It provides for infrastructure with staff and resources, and also the budget. So actually the Paris Principle try to address different elements of national human rights institutions which could be really monitoring the promotion and protection of human rights at national level.
And one of the national human rights institutions that exist at the moment is the one in the Philippines, which is called the Commission on Human Rights, which in itself is an independent office established by the Philippine Constitution of 1987 under Section 18 of Article 13. And the establishment of the Commission on Human Rights was after the People Power Revolution in 1986. And I'm very curious about the situation of national human rights institutions in Southeast Asia. Can you please tell us more about it?
There are currently, if we also include the Philippines, the one in the Philippines, there are currently 5 national human rights institutions in the form of National Human Rights Commissions: Indonesia, Malaysia, Thailand, and the latest one was established in Myanmar. But there is another type of national human rights institutions as well, and that is the Human Rights Ombudsman in Timor-Leste. So you have 6 national human rights institutions. Some of them are constitutional mandatory, but some were established by, for example, presidential decree. Actually, the case of Indonesia, the Indonesian National Human Rights Commission was established by presidential decree in 1993. In the case of Myanmar, it was first established by presidential decree as well. So you have different ways of establishing national human rights institutions here.
And you mentioned only a few countries in Southeast Asia have national human rights institutions. How about the others? Why don't they have a national human rights institutions?
Well, out of 11 countries, there are already 6.
Yes.
So there are 5 others without national human rights institutions. There has been a move towards establishment of national human rights institutions in some countries. For example, Cambodia. They started discussions on the establishment of national human rights institutions since 2000, as far as I recall. In Vietnam, the discussions on possibility to establish national human rights institutions started a few years ago. So there have been initiatives in some countries. But then it really depends on the readiness, on the willingness, the political will of the government, and also on the activeness of, of the civil societies, because some countries you do not have civil societies there. I may not mention which countries without civil society groups, but there are some. I would add that one of the factors would be the awareness, human rights awareness of the people within the country, in order for them to push for a monitoring body, an independent monitoring body in their own respective countries here.
And especially in countries without national human rights bodies, I am very curious, so how are human rights protected then at the national level?
In most of all countries in South Asia, they have constitution. So usually human rights may be to different degree. The recognition of human rights are there in the constitution. For example, in the Philippines you have the Bill of Rights. In Indonesia, the human rights and fundamental freedoms are quite well recognized in their constitution. And this is the case in other countries as well, but as I said, at different degrees of recognition of human rights there. So the constitution, from legal perspective, the constitutions recognize human rights. At the same time, although some countries may not have national human rights institutions, but they do have a system in place. For example, the Court of Justice. In some countries, they may have administrative court. The government, in international human rights treaties, it was provided that state parties have obligation to promote, protect, and respect human rights. So in different ways, they would be making sure that the infrastructure, the government infrastructure in different countries would be protecting and promoting human rights as well. Especially, as I mentioned, since human rights are recognized by their constitution.
So now we move from the national human rights situation to the regional human rights regime. And I'm very curious if Asia does have a human rights mechanism in place at the moment.
Unfortunately, Asia and the Pacific is the only one region without a regional human rights protection mechanism. As you may know, other regions, Americas, Europe, and Africa, they already have regional human rights protection regime, which include, legally binding documents and mechanisms. In all those three regions, they have regional human rights commission and regional human rights court. So as I mentioned, unfortunately, Asia and the Pacific is the only one without a regional human rights mechanism.
Why is this so? Why does Asia and the Pacific don't have a human rights regime at the moment?
If you look at the map, Asia and the Pacific is the biggest, is the really vast region, covering, as far as I understand, 57 countries altogether. And these countries are very diverse in terms of political, economic, social, cultural, and religious backgrounds. It's also a reflection of the concept of state sovereignty and non-interference. So it's really Westphalian concept of sovereignty and non-interference in internal affairs. Having regional human rights regime suggests that that regime would be looking into human rights situation of different countries. That in this region, this kind of concept is not well recognized yet.
So moving from Asia and the Pacific, I want to focus more on a region that is close to my heart, which is Southeast Asia. And I want to know if there are any regional human rights mechanisms in the ASEAN at the moment.
Yes, ASEAN has established since 2009 an ASEAN Intergovernmental Commission on Human Rights. In 2010, ASEAN has established another commission, which is the ASEAN Commission on the Promotion and Protection of the Rights of Women and Children, ACWC. On top of these two commissions, ASEAN also adopted different declarations relating to human rights. For example, in 2004, ASEAN has adopted an ASEAN Declaration on Elimination of Violence Against Women. 2007, for the first time, ASEAN has used the term human rights in the declaration, and that is the ASEAN Declaration on the Protection of the Rights of Migrant Workers. After the establishment of the ASEAN Human Rights Commission, the IHRP, that I mentioned earlier, in 2012, ASEAN has adopted the ASEAN Human Rights Declaration, which covers a broad range of rights. Actually, recently, in 2015, ASEAN has adopted a legally binding document, which is an ASEAN Convention on Anti-Trafficking in Persons, especially women and children. So you may see that ASEAN is not lacking of mechanisms and standards.
And in order to come up with an effective human rights regime, you need to have two key elements in place: mechanisms and standards. And I would like to discuss more about these two. Firstly, about the mechanisms that are in place at the moment in ASEAN. Can you please discuss it to us, Professor?
As I mentioned earlier, that ASEAN has already established two commissions. The IHRP, the ASEAN Intergovernmental Commission on Human Rights, and ACWC, ASEAN Commission on the Protection and the Promotion of the Rights of Women and Children. These two commissions have I would not say different mandates because the mandates cover both promotion and protection. Although there has been criticism that the two commissions tend to focus more on promotion rather than protection because there is no explicit mandate on receiving communications and complaints, no investigation mandate. So it's not explicit there. That's the mechanism. In terms of standards, I already mentioned earlier that ASEAN has adopted different declarations, including in 2012, ASEAN Declaration on Human Rights or ASEAN Human Rights Declaration, which is quite interesting, this particular document, because of course the basis of declaration was UDHR, but on top of rights recognized by UDHR, ASEAN Human Rights Declaration has also included, for example, right to development, right to peace, on top of political and civil rights and academic, social, and cultural rights. So if you look at the 40 provisions included in the declaration, then you will see a broad range of rights there. There is some criticism though against that particular standard, that particular declaration, when as far as saying that this ASEAN Human Rights Declaration is carries with it a kind of substandard. But personally, I may not agree with it, in the sense that there are some provisions which are up to international standard. There are some provisions which are adding on international human rights standards, as I already mentioned. But I do recognize that there are some provisions which go a bit below international human rights standards, in this case UDHR. In the same time, this ASEAN Human Rights Declaration also includes some provisions which reflect the concepts of human rights here within the region. For example, one on balancing human rights and duties, or another one, quite strong one, which is about respect for state sovereignty and non-interference in internal affairs, as well as reference to the concept which is vaguely defined. Actually, there is no such definition, at least in the declaration of public order, national security, public morals. As it has been seen, as quite problematic by civil society groups in the region.
And with the ones that you mentioned a while ago, are there any possibilities of strengthening the mandate of our mechanisms and even strengthening the standard that we have at the moment?
Well, there has been discussion so far to develop legally binding documents. For example, how to turn, or how to transform the ASEAN Human Rights Declaration into ASEAN Human Rights Convention, because that was the case of the Inter-American human rights regime. They start with the declaration and then other conventions were developed later. Actually, ASEAN could follow that kind of step towards the full-fledged sub-regional human rights regime in ASEAN. There has been also some efforts to strengthen the ASEAN human rights mechanism. So if you look at two other documents, for example, the ASEAN Vision 2025, for the first time that you look at the policy documents of ASEAN, that promotion protection of human rights and fundamental freedoms were very well articulated in the document. In a few points, it also said about ASEAN to strengthen the ASEAN human rights body as exists so far, especially strengthen the protection mandate of IHRP in this case. If we look at the terms of reference of the ASEAN Commission on the Promotion and Protection of the Rights of Women and Children, it is quite interesting because this commission, this ACWC, seem to be more progressive than AISA in terms of reference, in terms of mandates and functions, because the 16 mandates and functions in many ways implies, protection mandates as well, that they not only they could do studies, but they could also commission, the studies of human rights situation of women and children in the region. So the possibility for strengthening is there. Again, here depends on ASEAN member states, because some may be wanting to keep it as it is, but some others may be wanting to strengthen it at least in the near future.
Professor, from everything that we learned and discussed today, can you give us an idea if it's possible to still have a regional-wide human rights mechanism for Asia and the Pacific?
There may be some possibilities, because in the Asia and the Pacific, there are already existing sub-regional human rights protection regime. For example, in Arab states, the League of Arab States has established the Arabic Commission of Human Rights, and that was some years ago. The League of Arab States has also adopted the Arab Charter on Human Rights since 1994, but entered into force in 2008. So it took quite some time. The League of Arab States has also adopted the Arab Declaration on the Rights of the Child. So you see that is already one. Another one is in South Asia. The South Asian Association for Regional Cooperation has adopted quite a number of legally binding documents. For example, the SEAHRN Convention on Preventing and Combating Trafficking in Women and Children for Prostitution, the SEAHRN Social Charter, or even SEAHRN Charter of Democracy, and Action Plan on Climate Change. And except Action Plan on Climate Change, those documents that I just enumerated, they are legally binding documents. Unfortunately, in South Asia, there is no body. So they have legally binding documents, but they do not have mechanism. In the Pacific Island Forum start discussing at least by at least 10 years already, discussing the establishment of Pacific Island human rights system, and they set up a working group in order to prepare the ground for the establishment of the sub-regional human rights regime in the Pacific. So you see at sub-regional level, there are already a system in place. So I think the first possibility is actually to networking among these sub-regional human rights bodies, human rights system, and maybe gradually developing into regional-wide, the Asia-Pacific one.
And I really hope that this would happen in the near future.
I do hope so.
Thank you so much, Professor.